Now it's time to talk about how to transfer title from one property owner to another. We're going to also talk about different types of deeds and so forth. So, really, this entire module or chapter is going to be dealing with the types of title, types of deeds, why that matters. And I will tell you it matters, obviously, if you're going to be in real estate. And you see some of the other topics that we'll be talking about here. I'm not going to sit here and read all of it to you. But there's not a whole lot of stuff here. In fact, quite frankly, a lot of the stuff that is here should be just really review. Hopefully you'll see as we go through, because most of the stuff we've already talked about. But to get started here, we have to talk about how these estates are created. And we got to obviously start at the beginning when something called the original entry. But it says that was the transfer of power, license, or real property from the state or federal government to private individuals. So y'all, back in the day, y'all, who owned it all? Who owned all the land? Apparently the government. So if you were going to get any, you would have to get it from the government. Well, back in 1862, they passed what we know as the Homestead Act. Again, that was in 1862, just before my time, probably yours too. But President Lincoln enacted this law to encourage westward expansion. Trying to get people to move from the East Coast back towards the West Coast. Again, trying to encourage expansion. So the government would grant up to 160 acres of public land to settlers or individuals who had to pay a filing fee, which is probably not that much. But then they'd have to live and cultivate the land for at least 5 years. And then they were basically granted a homestead of 160 acres. Wouldn't you like to have that today? Woohoo! But anyway, that was the Homestead Act. But then there's a term here called patent, or a lot of times, or sometimes they'll refer to as a land patent. It says, but that was a document they used to convey property through a public grant. It refers to land being conveyed under this process. So if you were going to receive real estate, land from the government, then you would receive it through something they called a patent. Land patent just means you're receiving real property from the government. That's what patent means. Probably wouldn't be a bad term to remember. But now we're going to look at several ways you can involuntarily transfer property. Now, obviously, pretty much any time something is involuntary, which means obviously you did not voluntarily do it, involuntary kind of suggests not good, right? And there's several different ways we're going to take a look at here that land can be transferred involuntarily. Again, a lot of this should be just a review, but hey, nothing wrong with a review. So how can this happen? Obviously one through a judicial sale, where basically, if you don't pay your creditors, people you owe, then they might come take your property, sell it, and get their money back that way, right? That, in essence, is a judicial sale. What some or a lot of people have done, especially when they're looking at foreclosure, they'll file for bankruptcy, protection, if you will. But when you file for bankruptcy, there's what we call a Chapter 7 bankruptcy, and then there's also a Chapter 11 bankruptcy. And again, we're just trying to be real estate agents, so we're not trying to be attorneys and whatnot, so we're not going to get too deep into the weeds here. But just the Cliff Note version of this this bankruptcy impact on foreclosure. If they filed for Chapter 7 bankruptcy, then the ownership of the property will transfer to a bankruptcy trustee. Okay, that halts the foreclosure. The bank can't touch the property because the owner does not technically own the property anymore. It's been transferred over to a trustee, and says property cannot be reconveyed without the trustee approval. So in essence, they'll file for Chapter 7 bankruptcy to halt the foreclosure of the property. But then they could file for bankruptcy under Chapter 11, and said this is used by corporations or individuals needing a reorganization plan. But again, it does halt the creditor's foreclosure actions, but the process is much more complex, obviously, than the Chapter 7. That's about as deep as we're going to get into that. Main thing I would know here, there is two forms of bankruptcy, a Chapter 7 and a Chapter 11. Chapter 7 does transfer the ownership to a trustee, the bankruptcy trustee. That might be good to know. But then as far as that Chapter 11, that could get very deep. And again, we're not attorneys, so we just need to know there are a couple of ways this bankruptcy can take place. But what are the title issues surrounding foreclosure? There could be a few of them. Obviously, see 3 of them listed here. Unpaid tax liens, that's always an issue, because if they're not making their house payment, good chance they're not paying their property taxes either. So there could be some tax liens. There could be some unrecorded additional owners of the property. So obviously, if you're trying to purchase a property in this situation, and you can't identify who all the owners are, that can affect title to the property, right? Because there may be other owners involved and you didn't know about it. But then there's also disputes over the title and loan documentation. There's going to be disputes so I got to tell you, anytime you're dealing with a foreclosure sale, if you're representing that buyer, you better make sure they're aware of this. There could be all kind of issues with the title to this property. And if you buy it, just know if any of these issues exist and you're now the new owner, you now own all these problems that come along with it as well. So, there could be some risk in buying foreclosures. There's no doubt about it. But here's some of these challenges for the buyer. Obviously higher closing costs due to intricate paperwork. A lot of documentation. The legal fees, attorney services, is going to be delays. You can expect that. Usually because of all these title complications. But then under this risk of redemption, it says the homeowner may reclaim the property by repaying the debt before the sale. We talked about some of that in an earlier chapter, so I'm not going to get too deep into this right now. Again, really the whole point of this section right now is to let you know there are many different ways title to property can be involuntarily transferred, and we're just trying to hit on those. Again, most of them we've already talked about. A tax sale, obviously. If you don't pay your property taxes, the county's going to take your property, sell it at the tax sale, get their money that way. So, but you see there's some key points under this tax sale. Obviously it's an auction, and it's going to go to whoever the highest bidder is in this auction. But if you are the highest bidder at a tax sale, what kind of deed are you going to get? You're going to get a tax deed. Says the winning bidder will receive title via tax deed, which transfers ownership from the delinquent owner. I will tell you, there are some limitations on what you can do with that property with a tax deed. So, not going to get any deeper than that right now. Again, main thing to know is, tax sale is another way you could involuntarily transfer property. If you recall, we talked about adverse possession, acquiring title to another's property without compensation by occupying in a manner that conflicts with true ownership rights. So adverse possession is when someone tries, basically just moves in, takes over as if it's their property, and if they're not, if they're allowed to stay for some period of time, they can acquire ownership of the property via adverse possession. Now, if you recall, again, we talked about all of this before, but the requirements for adverse possession. Remember, by definition, it requires the actual, visible, hostile, notorious, exclusive, and continuous possession of the property. The key word there I would pay attention to, the word hostile. When they say hostile, doesn't mean they come in there with the guns drawn, shooting and so forth. That's not what they're talking about. Hostile means, I know this is not mine, but I'm going to help myself to it. That's hostile. It's not yours, you just take it anyway, or at least attempt to take it. Then that would, in that scenario, would qualify potentially for adverse possession. Again, it's got to be done in the open. Possession is kept to the claimant, excluding others, and the occupation persists for a fixed period of time. Again, all this stuff we've talked about. That's adverse possession. It could transfer through accretion, a natural process. If you remember, accretion is when you are adding where you're gaining or potentially losing land due to the action of water, right? That could certainly change your boundaries, where your property lines would be, because water has a way of moving land, right? So in some cases, that water could cause you to gain some land. Others, it could cause you to lose some land. So, alluvion, and again, this is all part of accretion. But one way accretion can take place is through alluvion. That's an increase in land, where the water, river, stream, whatever has deposited soil onto your property, so you're gaining land that way. Reliction is when you're gaining land due to the recession of water. If the water dissipates or recedes, then obviously as the water goes out, then you're gaining that land. Okay, so that's reliction. But then avulsion, now remember, that was a way you could lose land, but this is a sudden loss of land or movement of land. Alluvion, for example, that's a very gradual process over a long period of time, but avulsion is very sudden. Takes place very quickly. You see, avulsion takes place a lot of times if there's a tidal wave come in, or a major flood that just rips out large chunks of land all at one time. A mudslide, stuff like that. That can cause the avulsion. So might be worthy of remembering. Avulsion is a sudden movement, transfer of land. Things like alluvion, that's a very gradual. Takes it's a long process to get that done. All right. Another way to involuntarily transfer through eminent domain. We've talked about that, right? That's the government's power or authority to acquire land, private land, for public use. And under the Constitution, it's the Fifth Amendment that gives the government the right to basically take private property as long as it's for public use and just compensation be paid. Y'all, they could ask you, what amendment gives the government the right to take property under eminent domain. Again, that's the Fifth Amendment. So what is taking? Y'all, again, we're still dealing with eminent domain. And in case you hear the word taking, y'all, obviously the government is taking property from private owners for public use. Y'all, that's all they're talking about there. When it comes to these regulatory takings, y'all, I don't want to get too deep into this, but y'all, I will tell you, this is very interesting if you just want to really dig into this a little bit on what the government can and can't do. Because I'm going to tell you, the way it was written in the Fifth Amendment seems to be changing a little bit over the years. Because, y'all, it's very clear that, y'all, the government has the right under the Fifth Amendment to take private property, but it has to be for public use, and just compensation must be paid for that property. So they can't just take it, they got to pay for it. But what we're starting to see, y'all, the definition of public use seems to be getting awfully broad, as you're going to see here in just a second. In fact, there was a lawsuit under this Kelo versus New London. Y'all, this took place up in Connecticut. And here's the issue. Y'all, the city allowed a private company to take over an entire neighborhood under eminent domain for private development. Now, remember, the Fifth Amendment said the state can take the property under eminent domain if it's for public use, y'all, not private use. And this is saying, y'all, this New London, Connecticut, y'all, they took private property for a developer. Y'all, a whole neighborhood, they took it, for crying out loud. It says the property owners did dispute this action, went to the Supreme Court, and the homeowners lost. Y'all, all because they basically redefined what public benefit was. And here's what they did, this public use rather. It says the court held that that private economic development can qualify as public use if it benefits the public. So, y'all, basically what happened was this. The developer was saying this, by the state taking this property, giving it to the developer to develop it, that development was going to cause the land value to go up, and because the land value goes up, they can demand more taxes. Y'all, the government would be able to charge higher taxes on this property, and because the government is receiving more taxes, then that benefits the public because of the higher tax rate on the property now. That seems a little far-fetched to me, but leave it to the government. There you go. So, yeah, obviously there is a controversy there, widespread concern about governments using eminent domain to favor developers. Imagine that. I'm sure there was no money went to their campaigns, I'm sure. Yeah, whatever. But anyway, y'all, at least we know what eminent domain is now. But they are looking at some legislative changes. It says many states have amended their eminent domain laws to restrict condemnation. We'll see how that goes. Some states are trying to tighten the requirement of what on when and how they can use this eminent domain. We'll see how it goes. That's all we can do. All right, another way we can transfer involuntarily is escheat. Remember, escheat is when someone dies intestate. Intestate means they died without a will. And if you die without a will and the state cannot locate any legal heirs. Y'all, nobody steps forward and says, I'm an heir of the deceased person and I should get this property. Y'all, if nobody steps forward, the state cannot locate any legal heirs, then y'all got to do something with the property. So guess who's going to get it? The state. So under escheat, that just means the property transfers over to the state, because there are no legal heirs, or at least none that we can find. But then we have these laws of descent. Y'all still talking about escheat. Intestate succession. When someone dies without a will, the state determines who inherits the property. Y'all, we just talked about that. If there are no heirs, cannot find any legal heirs, y'all, it goes over to the state. But then we may have to partition the property. Y'all, it's a legal process by which co-owners divide or sell the property when they cannot agree on how to split it. Y'all, obviously they're talking about here, y'all, if there are heirs, and there are more than one, so there'd be co-owners, and these owners cannot agree to either sell it or keep it or whatever, then the courts will go through and partition the property. All right, well, here's your part, and then here's your part. That's what they do there. Some key points under this partitioning of the property. Y'all, there's what we call divisibility and local zoning, where the property must meet local requirements. Y'all, the lot size, zoning, and stuff like that. But some of the reasons for disputes: divorce, disagreement among co-owners, or other irrevocable differences. Irreconcilable differences, rather. Y'all can prompt the court intervention. Y'all, people, co-owners can't get together. They can't agree on what to do and how to do it. Then the courts will have to intervene. Which is what they're talking about here, the court intervention. And the court might actually even require you, as it says here, the court may just require all the property be sold. And then once it's all sold, then they'll distribute the proceeds according to the prorated share of each owner. That's kind of sad when you have stuff like that. But y'all, when we're talking about descent, y'all, again, intestate, when someone dies without the will again. Probate law governs the distribution of these deceased real and personal property. Y'all, hopefully there'll be heirs and it'll go directly to the heirs. Then there's something called regulatory taking. Y'all, I know I'm going through some of this kind of fast. Y'all, mainly again because this is really just review. And again, just making you aware of different ways property can be involuntarily transferred. But regulatory taking occurs when the government regulations imposed on the private property negatively impact the landowner. What they're talking about here is maybe the government does not take the property like through eminent domain, but they put so many restrictions and regulations that they've imposed that now all of a sudden now the owner can't do anything with the property. In fact, it may actually devalue the property from what it was. Well, that's considered a regulatory taking. They didn't take the property, but because of the government regulations, they're preventing the current owner from being able to do anything with the property. In essence, that's a regulatory taking. Y'all, the conditions for this to exist: loss of all economically viable use. Y'all, again, they no longer can profit from the land. And the owner's ability to earn a fair return on the property is basically eliminated. That's regulatory taking. Oops. But anyway, y'all, those are the ways you can involuntarily transfer property. Y'all, we're getting ready next to talk about ways to voluntarily transfer property, which is where we come in and what we prefer, the voluntary transfer.